Okay, welcome to the Civil Liberties and Civil Rights automated audio slideshow presentation for the class that we're missing due to the inclement weather. I've never done this before, so please bear with me as I try to teach this material to the slides. I'll probably be a little more low-key than I am during lecture just because I'm not standing up and there's nobody in front of me. So I'll do what I can, and I'll try to limit the ums and ahs because I know that's annoying during video recordings, although I know I've already done it a couple times. So first thing that we want to talk about in this unit here is we want to talk about the rights of the accused. We left off last class talking about how the sort of extension of civil liberties that we have from the amendments of the Bill of Rights of the United States. They start out with things like speech and assembly and the right to bear arms, right to religious expression, freedom from the state endorsing one particular religious belief over another. These are very important rights, but just as important are the rights that you have as somebody accused of a crime. When you're accused of a crime, you need to think about what that means. And what it means is that you're being accused of a crime by the state. The state puts you on trial in criminal situations. The state is the one then that processes the trial. The state is the one that then incarcerates you if they find you guilty of some sort of offense that you have to spend time in prison, or fines you if they believe that your actions mean that you owe the state financial compensation. Because all of these things are done by agents of the state, we need to have protections to make sure that the state is not playing favorites with itself as you go through the process of being accused of a crime. Our primary focus on establishing a set of rights of the accused is to balance the two tasks of having an effective law enforcement system that prevents people from committing crimes that violate people's sense of safety, people's sense that they can engage in commercial transactions with one another without being ripped off, things of this nature, balancing that against the state having complete and total license to just falsely accuse you of whatever they feel like. It's not always easy to get that balance right in the hardest cases. And the shooting incident with Trayvon Martin that you have to read about in your supplemental reading is sort of an example of how in the most extreme cases this becomes a very, very difficult task to know where to draw the line. What we try to do is draw the line as best as we can so that most of us get sort of the best possible package of the balance of these two things as is humanly possible. So the way that we limit the state is through giving you several different kinds of packages of rights. The first is the bundle of police limits on what the police are allowed to do to you in the process of investigating whether or not you have committed a criminal act. And there are a couple of key cases that sort of underscore the rights you have in terms of the limits of police to illegally search and seize property from you. One of these key cases is Miranda versus Arizona in 1966. You're probably very familiar with Miranda versus Arizona indirectly if you've ever watched a cop show, because in cop shows they always read people their Miranda rights when they arrest someone, right? You have the right to remain silent. You have the right to an attorney. If you can't afford an attorney, one will be provided for you, which we'll get to in a second why that's in there. But the Miranda rights come from this case in which this man, Mr. Miranda, was accused of a crime. He was arrested, and the police put him in an interrogation room, and they said, you'll confess to this crime if you know what's good for you. They started doing like the good cop, bad cop routine on Mr. Miranda, right? You put the person in the room, you make them sweat, you come back in, see if they crack a little bit. But Mr. Miranda was not from the United States. He was from a Central American country, I believe, where The police, when they say, you're going to confess if you know what's good for you, they start taking off fingers when they come back. He, not knowing what kind of rights he had, immediately confessed to whatever they wanted him to do because he thought that they were going to torture him if he didn't confess. So when he's tried in his jury trial, they have this confession, they convict him. But on appeal, his attorney says, look, my client wasn't aware of his rights. Even though the police were not actually trying to coerce a confession out of him, my client thought, Mr. Miranda that is, right? This is the lawyer giving the argument. Mr. Miranda thought that he was going to be coerced. And the fact that he thought he was going to be coerced is why he confessed to the things that he, in fact, now says that he didn't do. Because of this case, and the sort of trickiness of it, the court, first of all, overturned Mr. Miranda's conviction, and then secondly, set up the standard that police have to inform people of what their rights are when they are arrested on the scene. That way, there is no future incident where this kind of confusion can ever happen again. The second case on this slide under police limits is called Mapp versus Ohio. And Mapp versus Ohio says that the police cannot illegally obtain evidence and then use it against you in the court of law. Any piece of evidence that is not obtained legally by the police is inadmissible in court when you are tried for a crime. This is even if, no matter how devastating the piece of evidence might be. So if you find in somebody's house where there's a crime, if you go in without a warrant to that house and you search a bunch of stuff and you find like the murder weapon in somebody's sock drawer, but as the police, you didn't have legal permission to search that sock drawer, you've made a terrible mistake because now that murder weapon is inadmissible in the court of law. This case sets up a standard by which there are real restrictions on illegal search and seizure. Before Mapp versus Ohio, police would illegally seize stuff all the time. They would illegally search things all the time. And they say, oh, I'll get a slap on the wrist for not violating procedure, but at least this person who I think is a crook will go to jail. But you can imagine that for every person who is guilty, that the police are illegally rooting through their stuff for looking for criminal evidence, there are tons and tons of people they investigate that are not guilty and have their privacy rights violated and are totally inconvenienced by these searches and seizures, feel totally powerless by the police force that is supposed to be protecting them. And you never hear about those people because the police don't bring charges against them. So Mapp versus Ohio ends up being a very significant case in that if the police violate your right against illegal search and seizure, they can't use any evidence they obtain in the process of violating your rights. They have to get a warrant from a judge to search your property without permission. Moving on to pretrial rights. So you have rights, first of all, the police limits are rights that you sort of have when you get arrested. Pretrial rights are rights you have in preparation for your legal defense once you have been accused by the state of a crime. And the most important pretrial right that has ever been established is the right to an attorney, which we mentioned before is in Miranda versus Arizona. One of the Miranda rights that people read to you is that you have a right to an attorney. The right to an attorney was set up in a case called Gideon versus Wainwright. And the reason that this right gets established is because, generally speaking, people who are arrested for crimes tend to be of lower socioeconomic backgrounds in the United States, and they tend to, as a correlation with those lower socioeconomic backgrounds, they tend to have lower levels of educational attainment. And so this leads to an awkward situation where the police are arresting poorer Americans as a sort of general rule when it comes to criminal activity, which leads them to have a bit of an implicit bias that when they're looking for someone who's committed a crime, they sort of implicitly expect that it's going to be somebody who is of low educational attainment and of low socioeconomic status, because that usually tends to be the case. But remember, in the law, we don't want to throw people in jail based on statistical likelihoods, right? We want to throw people in jail when we are really, really sure that they deserve to be in jail. Because to be falsely incarcerated is like the greatest possible infringement on your liberty that you could think of. So you can imagine that this is a bad situation where the people who are most likely to be falsely accused of a crime are in fact likely to be people who aren't going to be able to articulate why they're not guilty when they're being investigated. So then they go to court and they're being prosecuted by the United States. And the United States attorneys tend to be extremely well-educated people. They're very important jobs in our society. They're not just important for the way that the government functions, but they're also important in the legal community because you get a lot of valuable experience. Being a United States prosecutor, or being a state prosecutor, is a great springboard to a really high-paying job in a law firm once you leave the state office. So America's smartest, most ambitious law students oftentimes end up taking these prosecutor jobs. And so what you end up with is, if someone is too poor to afford their own attorney, you end up with somebody sitting there who is defending themselves, is of really low education, and they're going up against like the Harvard Law School valedictorian on their court date. And so even if they're innocent, the process is not likely to reveal that this person is innocent, because the Harvard guy is just going to crush them in the courtroom and it's going to look really awful. And the jury's going to have no problem whatsoever sending this poor slob who can't explain themselves to jail, as this Harvard person very eloquently says why they're guilty. What the Supreme Court decided in the early 1960s is that every American has the right to a legal criminal defense from a professional licensed criminal defense attorney, because otherwise the justice system isn't the same for everybody. Now, you don't get the right to have like Johnny Cochran or some famous expensive trial attorney, but you get somebody who is certified as a competent attorney. This is guaranteed to you now by the Constitution of the United States. And the court says, look, this is implicit in the 14th Amendment. Every person is entitled to due process of law. And due process of law means having somebody who knows the law tell people why it is that you didn't break it if you want to plead not guilty when you're charged with a crime by the state. So Gideon is an important case for making sure that everybody has access to some sort of adequate legal defense. We do this in two ways. We provide people with attorneys in two ways. One way is we have public defenders' offices that the state literally employs people to defend people who can't afford their own attorneys, the same way that the state pays for people to prosecute those people charged with crimes. The other way that people can get a criminal defense attorney when they can't afford them is that the government offers various kinds of financial incentives like tax breaks and things and civic awards to private law firms whose attorneys donate some of their time to defend people who cannot afford those private attorneys' fees normally. This work in the legal community is called pro bono work. It means for good. It's not pro bono. They're not doing it for you too. They're doing it for the good of society. And the government sort of says, to encourage them to do it for the good of the society, the government gives them sort of material incentives to do it as well. So whether or not attorneys actually do it for the good of society or not, the good of society gets done when they volunteer their time to privately defend these people. So we have both a public solution and a private solution to the Gideon v. Wainwright problem. Finally, we want to talk about on this slide trial rights. And trial rights are the rights to a fair trial you have. Once you are actually in court, you have your attorney, the police haven't violated your rights in investigating you. If you're still in court at this point, you might think, wow, we've done a lot to protect you, but there's still one more thing that has to happen. it has to be the case if we're all guaranteed due process and equal protection under the law. It has to be the case that our criminal trials are the same across the board. So that if I get accused of murder in Minneapolis and you get accused of murder in Milwaukee, your trial should not look radically different from my trial in terms of what is and is not permissible to take place inside the trial. That the trial needs to be responsible to the facts. It needs to be responsible to all of the duties the court has to respect my rights as a citizen. The court has to respect the idea that I need to be found guilty beyond a reasonable doubt. The court has to be responsible to explaining the law clearly to jurors before they vote on whether or not somebody broke the law or not. All of these issues of fairness of what happens in the courtroom are what we call trial rights. So there are two cases underneath this trial rights case, and they're both Georgia cases. Furman v. Georgia and Gregg v. Georgia both concern Georgia's death penalty. And this is an interesting lesson, not just on trial rights, but an interesting lesson, too, on how the Supreme Court goes about doing its business. So in Furman versus Georgia, it turns out that the Georgia death penalty worked in the following way. If you were found guilty prior to 1972, I should say, if you were found guilty of a crime that rose to the level of possibly including the death penalty, the judge would simply sentence you from the bench. So if you're found guilty of murder, the judge would look you in the eye and say, I think you're like a cold, heartless, terrible person, so you get the death penalty. Somebody else, you killed someone, but I kind of like you, so you get life in prison. You could probably already start to see the problem. There's sort of an arbitrariness with the judge sort of looking at someone being like, I can tell how bad a man you are by like looking at your eyes and reading into your soul. I mean, this is not a very methodologically strict way of deciding who does and doesn't get executed by the state. If you ever saw the film The Shawshank Redemption, right, at the beginning when the judge is chastising Tim Robbins' character, Andy Dufresne, for being a cold and heartless killer because he seems totally emotionally unmoved during the trial, it turns out he didn't even do it. Spoiler alert, I guess, if you haven't seen this, 20-year-old classic film. But this is, the judge is way off, right? So it turned out when you look at the statistics of Georgia that what constituted being a crazed killer who needed to be put down by the state rather than someone who deserved life incarceration or a long prison sentence with a chance of even rehabilitation, a lot of it boiled down to whether or not you were black. And that was a very disturbing thing to find in the in the statistics of Georgia's death penalty sentencing. So the court said you can't just have the judge. Supreme Court heard a case where someone challenged the arbitrariness of this, and the Supreme Court ruled and said to the Georgia court, you can't just have judges from the bench making up these sentences about life and death. So what Georgia did, based on this Furman v. Georgia case, is they went back and they redid their death penalty rules and procedures so that now, after 1972, if you are found guilty of a crime and the prosecutor wants to pursue the death penalty, the prosecutor notifies the judge of this fact. And what happens is, for the trial of whether or not you are guilty, you're judged by a jury of your peers, and all 12 have to decide you're guilty for you to be guilty of the crime. If you are found guilty under the new Georgia rule, they then bring in another jury. They bring in another jury of 12 people, and there are arguments for and against by both attorneys as to whether or not the client deserves the death penalty, given the fact that they've been found guilty. If all 12 jurors agree that the person deserves the death penalty, then they're sentenced to death. But if there's not, the same standard of being found guilty, basically. So if one juror thinks that you don't deserve the death penalty, then you're not going to get the death penalty. This system was challenged in Gregg v. Georgia in 1976 because Mr. Gregg was going to be put to death, and he thought, well, Hail Mary, maybe the Supreme Court decided in 72 the way they did because they don't like the death penalty. It turns out that the court wasn't interested in whether or not the death penalty is a good or a bad idea, not because they're not interested in it, but because the Supreme Court feels like that's something that we decide as a public through our legislature, through the making of our laws. So if in the future we decide we don't want to have the death penalty anymore, if we elect representatives who abolish it, the Supreme Court's totally fine with that. But if we have representatives that don't abolish it, the Supreme Court doesn't interfere and say, well, we don't like the death penalty, we think it's immoral, so we're going to say it's unconstitutional. That's not the job, that's not the business of the Supreme Court. The business of the Supreme Court is to judge the fairness of procedures and laws as they exist on the books, and whether or not anyone has the authority to do what they're doing. And so the court looked at this second Supreme Court challenge in Gregg v. Georgia, and the court said, no, this is fine. Because having a jury unanimously decide that you deserve the death penalty is far less arbitrary than having one person sitting at the bench who's probably, an old white male, as opposed to a jury of your peers. That's a major difference in how arbitrary your death sentence is if you've been sentenced to death. And so that Georgia system is still in the books, and various variations on that system are basically what any state who has the death penalty still, that's basically the kind of template for the system they use. That's a trial rights issue. These two death penalty cases are trial issues because they're about the fairness of the procedure you get when you are in court. What does my trial look like? Are the rules being followed? Do the rules look like, for me, what a reasonable person would say, yeah, that's pretty fair. Right? And so in the Furman v. Georgia situation, a reasonable person would not conclude that having some 80-year-old judge look at someone and be like, I don't like you, you're a whippersnapper, death. That this is not sort of a fair way to sentence people to death. But if your jury of your peers is selected and they decide whether or not you decide the death penalty, you need to say they have 12 votes, and if anyone votes that you don't deserve it, you're free to not be executed. But they all voted that you did deserve it. That's a totally different standard. That's a much more reasonable standard, regardless of your view on whether the death penalty is just. Even if you think the death penalty is abhorrent, at least it requires this heightened level of scrutiny for it to be handed out to anybody in particular. Okay, so that's rights of the accused. I want to talk real quickly about the right to privacy. As you know from your reading, the right to privacy starts with Griswold versus Connecticut in 1965. Estelle Griswold is fined for selling birth control to a married couple. The defense that Griswold gives is that there's an implied right to privacy in the Constitution because almost all of the rights guaranteed in the Bill of Rights are basically just different kinds of privacy rights. Being that is the case, what could be more private than what married couples decide to do in the privacy of their own bedroom? So the reason that this case is controversial, one suspects historically, is not necessarily that argument itself is so controversial, although you read the dissenting opinions from the other judges, and they're pretty strongly argued as to why they don't want to use the Ninth Amendment in that way. The real reason that the case remains sort of controversial is because it leads to other privacy cases that social conservatives really, really hate. The first one is Roe versus Wade in 1973, which is about abortion and whether or not somebody has the right to get an abortion. The court's position in Roe versus Wade, and I can't state this enough, is not that abortion is great, which is sort of what opponents of Roe v. Wade sort of painted as this decision in which the Supreme Court has legislated morality for all of us. That's not really what they've done. What they've done is they've said that the issue of abortion is really hard and really controversial, and because of that, if we respect the liberty of individuals so much, then we have to respect the fact that people have deep, reasonable moral disagreements about abortion. And because of that, it's wrong for the state to intervene one way or the other. Right? That's actually the official sort of position of Roe versus Wade. It's not abortion is good and it's not abortion is bad. It's abortion is really, really hard to figure out, and there's no reason why the state should be telling one group or the other that they are the winner in this deeply divisive moral controversy. If you don't want to have an abortion, don't have one. If you do want to have an abortion, the state probably shouldn't be in the business of telling you not to. That's whether you agree with that position or not is I'm totally not interested in. You can agree, you can disagree. As I said, there's deep moral disagreement about this in our country, and we're not going to reconcile or solve it in this class, nor would I want to. But my job is just to explain to you what the logic of the decision is, and that was the logic of what the decision is. 2003 is a case, Lawrence versus Texas, that's sort of the next plank on this sort of tower of privacy rights cases, you might say. Lawrence v. Texas is about a law that outlaws sodomy, and in particular, basically, by extension, it outlawed homosexual activity. And Lawrence v. Texas overturns that Texas law. It argues that outlawing certain kinds of sexual activity is a violation of the 14th Amendment because if the activity is not outlawed for some people but is outlawed for others, I'm not going to get into any more detail about what those activities might be, but you can imagine certain sexual activities that maybe men and women could do that would not be illegal, but if two men did it, they would be illegal under a sodomy law. That's taking different people and treating them differently for doing the exact same thing. The Supreme Court said that's a violation of the 14th Amendment. It's also a violation of people's right to privacy. If people are consenting adults are doing things that are not affecting anybody else, then under the law, that's nobody else's business. So that sort of slide from Griswold v. Connecticut to Lawrence v. Texas, slide isn't the right word, it sort of implies a negativity, but that movement through history, that is the big reason why the privacy right cases are controversial, not as much the logic of them, but just that there are a large number of people in American society who are unhappy with the policy implications of these. And the court, if they were asked to defend themselves on them, would just throw their hands up and say, we don't make policy. We're enforcing fairness. If you don't like the way that fairness shakes out, that's not our job. Our job is not to make you happy. Our job is to make sure the rules are fair for everybody. Lots of times when people lose, they blame the refs. And it's the court does what the refs do. When you boo at them or you yell at them, they shrug their shoulders and say, "This is my job. This is what I do." So that's the civil liberty coverage that I wanted to get through. We're going to now move on to civil rights. Civil rights are a very important part of our history. They are an important part of our law and our politics. It is very difficult to measure just how important the legacy of discrimination in all of its forms have been in making our society the way that it is. There is a common attempt by our society to sort of pretend that this is not the case, but when you look at the plain facts, it becomes very hard to believe that mythology, that discrimination isn't an incredibly defining element in American society. And our attempts to reconcile this fact about our past with our present is really important because, well, for a couple reasons. One, if you want to make things better tomorrow than today, you have to know what happened tomorrow, or you have to know what happened yesterday in order to make things better. And secondly, it's just important to understand why things happen the way they do. There's really no way that you can possibly look at the kinds of political and legal battles that take place in the United States without looking at race. It is very difficult to look at something like Florida's Stand Your Ground self-defense law and see it as anything other than sort of something that harkens back to the era of Jim Crow in terms of being able to threaten violence for minorities who look threatening or suspicious to you. And it's not surprising based on this that there is an enormous racial divide in the American South where there are stand your ground defense laws between white people in favor of it and black people and other minorities who are not in favor of it. And it makes you might say, well, why, it seems like if everyone is carrying guns and can shoot other people in self-defense, everyone's equally exposed. But there's an implicit sort of understanding that the law is really in place to defend yourself from black people if you're white. And that's sort of the only real thing that can explain the split in opinion between the two groups on an issue like that. So civil rights are extremely important. And I should say that's not to say that there aren't other arguments for why people would defend the stand your ground law in Florida or something like that. People might talk about self-defense or their right to carry a gun. But the fact that there seems to be no fear of getting shot amongst white people and there's an extreme fear of getting shot against black people is a very suspicious element of the stand your ground law. All right. Well, anyway, I don't know how it got so far off on that. Let's talk about, again, let's just bring up again the distinction between civil liberties and civil rights. Civil liberties are boundaries across which the authority of the state cannot cross. Civil rights are equal treatment under the law for all people. That's what civil rights are about, okay? And that's what we're going to be talking about for the rest of this slideshow. Judicial standards for laws that target groups. The Supreme Court's guidelines for enforcing and upholding laws to make sure that they are not discriminatory is they divide groups of people who might be targeted by discriminatory laws into three classes. The first of these three classes is race, and it is called a suspect class. The reason that race is called a suspect class is not because we're suspicious of racial minorities, it's because we're suspicious of laws that target minorities. Okay? The Supreme Court rarely thinks that laws that discriminate based on race are constitutional. They get a standard of strict scrutiny when it comes to interpreting those laws. What this means is that if you have a law that treats blacks different from whites, Native Americans different from whites, Latinos different from everybody else, etc., and it can work the other way around too. It could be laws that favor blacks instead of whites. These laws get strict scrutiny. Right? Affirmative action programs have been shut down in many states by the Supreme Court because they give minorities advantages that are not available to whites, and that's a violation of the 14th Amendment, just as much as segregating in favor of whites would be and not extending the privilege to blacks. So the court very, very rarely allows a law to stand based on racial distinctions at all. There are a few exceptions. A lot of them have to do with health policy, where different ethnic groups are just genetically predisposed to get certain diseases more, and so laws that target them, that hand out resources for those genetic disorders, those are allowed by the court because that's something that's not really based on denying privileges, but trying to equalize health for everybody. But in general, laws that target race, that treat different races differently, are no-go, okay? The next class is what we call quasi-suspect class. Gender is the sort of big example of a group that is a quasi-suspect class. There are sometimes cases where rules that treat men different than women are constitutional. There is the standard for deciding when a law that treats men and women differently is constitutional is based on the standard of compelling interest. So here's a law that is definitely not constitutional. A law that says that women cannot be firefighters, full stop. That law is not constitutional. because it is just based on gender and it has nothing to do with any sort of appeal to a fact about the difference. There's nothing compelling about saying women can't be firefighters because they're girls. But if you were to have some sort of standard for being a firefighter, you have to be able to carry 350 pounds on your back in this test for like 100 meters. I don't know much about firefighting, but I assume something like that is a test, okay? If no women in your community can pass that firefighting test, that law might still be able to stand because the discrimination is one in which the compelling interest is that, the fire department can say, look, being a firefighter means carrying people out of burning buildings. So if you aren't strong enough to carry a person out of a burning building, you can't be a firefighter, right? You're risking the life of the person in the burning building otherwise. The court allows standards like that to pass muster so long as they're reasonable, so long as there's a compelling interest there that makes sense to a reasonable person. So, being able to carry a body 100 yards, that's a compelling interest standard that the court might uphold, right? And there are women who can do that, who can pass that test, right? Can more men pass that test than women, just sort of based on the facts of American society as they are right now? Yeah, that more men can pass that test than women. But some women can pass the test, and as long as the women who do pass the test aren't denied the job based on their gender, then that's the law is not discriminatory in the same way as saying girls can't be firefighters would be, right? It's important to remember that these kind of laws have to be compelling in some sort of way that makes sense. You can't have, for example, some fire departments, in order to keep women out, tried to have a standard where they had a height requirement. You had to be at least 6'4" to be a firefighter, almost as if it's like one of those rides at a theme park where they have like the red line. You must be this tall to ride the roller coaster ride. Except it was you must be this tall to be a firefighter. And the whole point of the rule was that there's no advantage to being super tall in fighting fires. But they were just trying to keep women out without saying we're keeping women out. And the Supreme Court said to rules like that, no. The rules have to have something to do with the actual job of fighting fires. If you can't come up with some reason why this is necessary, then it can't be a standard. The third group are non-suspect classes. These are classes in which most of the time rules that target them are usually constitutional. The court evaluates laws that discriminate against non-suspect classes on a rational basis. They ask, what would a reasonable person conclude about this law? So, for example, you're not allowed to vote before you're 18. You could argue, right? Well, that's a violation of the 14th Amendment. That's age discrimination, right? It's saying that young people aren't as smart as old people. And while it might be true in general, it's not true for everyone, right? We all probably could think of some 16-year-olds who are more qualified to vote than some adults that we know. So how is that fair? Well, the court says, look, a reasonable person would accept the idea that it's valuable for society to have some sort of age restriction on voting. And the way to do that is just to sort of draw an arbitrary line in the sand that's not completely fair to everyone in terms of that, there's smart 16-year-olds who can't vote in the next election. Sure, that's going to happen. But the thing about targeting people by age is that everybody is a child for 18 years, and everybody then is not a child after 18 years, right? It doesn't matter if you're black, white, Latino, Asian American, Indian American, Native American, woman, transgendered. It doesn't matter, right? Age happens to everybody. And it happens to everybody the same way. So discriminating by age doesn't discriminate in the same way that discriminating by race, right? We don't all sort of cycle through all the different races of life, but we do cycle through all the ages of life, right? Wealth is also not a class that is protected for discriminatory laws. Things like progressive taxes are not a violation of your rights against the 14th Amendment. Because for one reason, wealth is not a permanent fact about any one particular person, right? Today I might be broke, tomorrow I might win Powerball, I might be rich, the next day I might spend it all really stupidly and lose it all, right? So wealth is too fungible to count as a class by and large. So laws that target wealthy people differently than poor people, or laws that give privileges to poor people that other people don't get. These, as long as there is a rational reason to justify those transfers of money or those laws that target people differently, the Supreme Court says that those are okay. Now, the interesting development in your lifetime that's happening is this last one here where there's a question mark, and that's sexual orientation. Is sexual orientation a suspect class, a non-suspect class, or a quasi-suspect class? Well, you're getting a real lesson in the way that we have to re-coordinate the law to the changing beliefs of society over time in thinking about a question like that, because for the first 200 years of our country, it was in this non-suspect class group, but it largely was in this non-suspect class group because Americans had very discriminatory social and moral values towards people of different sexual orientations. As sexual orientation becomes less acceptable in sort of the public morals of American society, discriminating against becomes less acceptable to public morals. I think that what you might see is that sexual orientation is on a probably rather rapid journey from non-suspect class to suspect class, or maybe quasi-suspect class. And it's a real problem where it is in the law. There was a case in Iowa a couple years ago in which a woman had outstanding performance reviews at her job working the desk at a hotel in Iowa as the concierge receptionist. She was fired, and according to internal memos from the company, she was fired for, quote, having an Ellen DeGeneres look about her. So she was fired for looking like she was a lesbian. This ended up getting upheld by the court. They said that it was okay to be fired for this reason. You have to remember that the court is full of people who are of at least 2 generations older than most of you, and they tend to hold those sort of moral prejudices a lot more as a matter of course than probably most of the audience who's hearing this would hold them. Probably a lot of you are appalled to hear that story. When I told this story in my last class live, people reacted audibly and visibly and couldn't believe that that could possibly be a decision by the United States court system. That is something that you in your lifetime will change. Your generation is going to change the box this ends up in because, again, remember my rant from earlier in the course, the court is actually very democratic and it responds to the interests and the values of the people as they change over time, and this is a good thing. So while sexual orientation remains in this bottom box for now, it's moving up in the world. And as it moves up in the world, there will be less and less breathing space for laws that discriminate. The gay marriage laws that are getting struck down, Lawrence versus Texas, which we already talked about, they're already showing you the trajectory of where this is going. And once these things start, they're almost never stopped. So that's something to keep an eye on in American law when you sort of check your newspaper for the rest of your lifetime. So now what we're going to do is we're going to talk about different kinds of discrimination from sort of a more historical perspective. And the reason that we're going to do that is because the laws we have about racial discrimination come directly from our history of racial discrimination. So you can't understand how we protect against it without understanding how we got to the sort of need to protect them in the first place. We're going to start by talking about discrimination against African Americans, but we will, and that's where this slide presentation, probably mercifully for you, this slide presentation will end, talking about African American civil rights movement. We will pick up in class then talking about women's rights. We'll talk about Native Americans. We'll talk about disabled Americans. And this will give you sort of a brief bouquet of the kinds of discriminatory practices that have existed and have tried to be corrected over time by our government as we've tried to sort of coordinate together to come up with better solutions to sort of rectify some of the problems that have been created historically. Okay, so we're going to start with race. The first thing to talk about is the transatlantic slave trade. As you can see from this picture, the slave trade was massive. It took an enormous amount of people out of the continent of Africa and moved them all over the world. What you might not have known is that the United States is actually but a small fraction of the overall history of the slave trade. You see the thickness of these arrows correspond to how many slaves were taken, were kidnapped, and sold to people in other places. You'll notice that Brazil has had almost as many slaves imported into it as all of North America put together, if not more. The bulk of African slaves ended up going to South America. Very few as a percentage went to the United States. And when I say very few as a percentage, I just mean as a percentage, right? 600,000 slaves were brought into the United States through the slave trade, which is not, if you're one of those 600,000 people, it's of zero comfort to you whatsoever that you're but a small percentage of all the slaves that were taken. In no way does this absolve the United States from its sort of moral responsibility for having done this. But it's just as a historical fact, we talk about our slave trade and our participation in it a lot. Because we talk about it so much, it's much more prevalent in the United States. The awareness of it is higher, which gives you the sense that it was a much bigger problem in the United States than other places, right? Brazil does not talk about this, not because they didn't have more slaves, but just because they don't have as open a society as we do. So one of the advantages you can already see of having an open democratic society is that even when you're thinking about sort of the dirty laundry of your society, the bad things your society does, we have this very healthy and open dialogue about what we've done to one another and what we've done to other people that allows us to try to make restitution for the things we've done, and also tries to make sure that these sort of most awful things we've ever done don't ever happen again, as best as we can try to prevent them. Whereas in other countries who don't talk about the problem, that means they're not working on the problem. And if you're not working on the problem, then it doesn't get better. So 600,000 slaves brought to the United States. Just to give you a sense of just how small a percentage of that the United States is involved in, 12 million Africans were abducted during the transatlantic slave trade. And let me leave you with one other statistic before we move to the next slide. Another 20 million Africans died in Africa who were not abducted as a direct result of policies of colonialism. In the Belgium Congo alone, 10 million people were estimated to have been killed by Belgian government forces during their occupation of the Belgian Congo. If you want a really depressing but fascinating book about the history of this, there's a book called King Leopold's Ghost by Jennifer Hochschild. I highly recommend it. It's a great book. But as you can see, the effect on America culturally has been profound from having the legacy of slavery and then everything that is going to follow that. But if you think that that's been disruptive to American history, you can imagine the kind of impact that this era had on Africa. 32 million people, either from kidnapping or from murder, were drained out of the continent of Africa in the period of 400 years. That is a devastating loss of people. Think about how devastating when like a tsunami hits Southeast Asia, right? And Indonesia and some of the Southeast Asian coastal countries have their coasts devastated and thousands of people are killed when the water comes and smashes into all the people in the coastal towns. And it takes them years and years to recover, right? There was a story the other day that Governor Christie was complaining in New Jersey about, and complaining sounds sort of like negative, I mean, rightfully so complaining, that all of the federal aid that's supposed to help New Jersey recover from Hurricane Sandy hasn't come. Right? Several years later, right, 2 years after a hurricane has struck New Jersey, they haven't completely economically recovered from the damage of this hurricane. So you could imagine how long it would take to recover from losing 32 million people from a continent. If losing thousands is sort of visibly devastating over a long period of time inside our own country, right? Think about New Jersey after Hurricane Sandy. Think about New Orleans still after Hurricane Katrina, right? These are fractional disruptive forces compared to 32 million people being taken. And on that theme, I just wanted to show you this graphic to show you just what a global impact the slave trade had on the world. Why the world looks like the way it does today, in part, is defined still by slavery. Harvard political economist Nathan Nunn said 72% of Africa's income gap with the rest of the world and 99% of Africa's income gap with the rest of the developing world can be attributed to the effects of the Atlantic slave trade. In other words, the reason that sub-Saharan Africa's gross domestic product is so far behind the European Union and the United States, Asia, more developed parts of the world, is because of all of the people that they've lost, all of the damage that colonialism did, all of the damage that slavery has done. Most of that difference is explained by those two horrendous parts of African history. But an even more interesting question that Nunn points to with this 99% difference is, okay, Africa is not as developed as the United States, it's not as developed as Europe, it's not as developed as Japan and South Korea, fine, I get it, right? But why is Africa so far behind South America, who are also colonial possessions for this same time period? Why is Africa so far behind in development than Southeast Asia, which were colonial possessions? Why is there no India of Africa, right? Why is South Africa so far behind South Korea, so far behind India, so far behind New Zealand, so far behind Brazil and Argentina? And the answer for that, according to Nathan Nunn's very exhaustive study on this that he published, the answer is that it's almost 100% because of the slave trade, right? Slaves went into those other developing regions from Africa to improve their economies during the era of colonialism, and they went out of Africa. And that difference has destroyed the African economy, and they haven't recovered from it. You might say, well, gee, slavery's been abolished everywhere for like 150 years. What's the deal? But you have to remember, again, if you keep it in proportion, right? If it's not surprising that New Orleans hasn't completely recovered from Hurricane Katrina after 8 years, how many years would you reasonably expect it to take for a continent to recover from losing 32 million people over the course of 400 years? Right? This is going to take Africa a long time to get back on its feet from. This is a economic and political shock that explains a lot of the poverty and chaos of African politics today. We have played a role in making Africa the way that it is by being engaged in the slave trade, as have almost every other country around the world in some way or another. But it really brings home the point that this is sort of something that we are just not able to say is not our fault, is not our responsibility. It's definitely the responsibility of anyone who engaged in the slave trade to try to help recover from the devastation. And if you feel compelled morally to give money when a tsunami hits Southeast Asia, or when Japan has its devastating storm that knocks its nuclear reactor offline, if these kinds of tragedies make you feel like you want to reach out to your fellow man and help them, then that impulse should be there the same way for Africa, because this is a problem that is entirely not of their own making. Okay, so just putting the slave trade in context, bringing it back to the United States, why was it that people were able to sort of defend slavery with a straight face? Well, at the time, there were three stories that people told in the South in particular to justify why slavery should exist. The first story was theories about the racial superiority of whites, and there are numerous versions of this. They're all heinous, they're all false, and that's pretty much all that you need to know about it. There are also theories about how the care of the parental slave owner was the best possible life for the ignorant African. So there were stories at the time, children's books even, that were called things like the Little Black Sambo, and it was about the Little Black Sambo portrayed African Americans as these sort of happy, childlike, ignorant people, and they needed white people to look after them the way that children needed a mommy and a daddy to look after them. Isn't that horrible? Yes, yes, it is. But this was very popular. It was popular to the point that even as late as the 1960s, there was a restaurant chain, a family restaurant chain, like an Applebee's kind of chain, that was called Sambo's, and it was a reference to this story, which is also equally horrible. Eventually, people sort of were really appalled by this, and they changed their name. But this legacy lived on for a very long time. And finally, the last sort of main justification for slavery was that the arguments that the South gave that the real issue was federal intrusion rather than the moral repulsiveness of slavery itself. There's a saying in the law, if you're an attorney, if the facts aren't on your side, argue the law. And if the law's not on your side, argue the facts. So the South sort of played this game. So if the facts on slavery aren't on your side, you argue the law. Oh, well, you can think what you want about slavery, but you don't have the right to tell us what to do, right? That argument is usually the last refuge for people who know that what they're doing is in the wrong, right? Oh, well, who are you to say? You defend yourself that way unless you have some doubt that you're in the right. So these were the kinds of things that took place in pro-slavery dialogue, and they ultimately were not strong enough to get the North to sort of lay off a political crusade to abolish slavery, and this leads to the American Civil War. This is a picture of an assault on a fort, a very famous assault on a fort by the I want to say is the 54th Massachusetts Regiment. I should have looked it up before I started talking about it on this slide, but oh well. This was one of the famous African-American regiments from Massachusetts led by a white commander named Robert Gould Shaw. They all perished in the assault on this fort. If you ever have seen or get a chance to see the movie Glory, starring Matthew Broderick and a host of famous African-American actors, Denzel Washington, Andre Braugher, Morgan Freeman, it's about this regiment and their assault. It's a tearjerker. Let me just warn you about that. But the Civil War cost an enormous amount of human lives, and in the sort of resulting conflict, there needed to be some sort of way to keep the South in the Union that was going to set them on a different course, but not be overly harsh on the South so that they felt like they were being turned into second-class citizens by the North as a conquered people. The result of this is the Civil War amendments. The way that the United States brings the South back into the Union is they require each state to get a certain amount of people to swear their allegiance to the United States, and the southern states have to agree to ratify the 13th, 14th, and 15th Amendments. The 13th Amendment abolishes slavery. That's pretty straightforward. The 14th Amendment, which we've talked about repeatedly already, gives equal protection under the law and a prohibition on office holders from states in rebellion to represent the United States. That means that if you worked for the Confederate States of America to actively overthrow the United States, you can't run for Congress because we don't trust you, basically. So that obviously is not a really valid part of the 14th Amendment anymore because there aren't any states in rebellion. The 15th Amendment says that the right to vote cannot be abridged based upon race or prior servitude. These are the three key amendments that the North gets to sort of secure what it was fighting for during the Civil War. And you'll notice that all three of them are basically targeted at racial equality in one way or another. So immediately after the Civil War, for a period of about 15 years, African Americans really have a chance to flourish. Even in the American South, they have a chance to flourish. And this creates some problems socially. And what ends up happening is that white Southern politicians start working to try to phase out African American participation in Southern politics. And the way that this gets its biggest push is in 1876, the presidential election between Samuel Tilden and Rutherford B. Hayes. There's doubt as to who won the election. Once again, Florida screwed up. They sent in different counts on who won what electors from the state of Florida. Good old Florida, unable to count their votes yet again. And so the contest between Tilden and Hayes, there was not enough electoral votes for either of them to determine the winner. It went to Congress. Congress was deadlocked. They couldn't get enough votes to make either person president. What happens is a deal gets struck. The deal that gets struck is that Rutherford B. Hayes, the Northern Republican, gets to win the presidency. In exchange, though, the North has to basically promise to stop enforcing racial equality in the South. What this leads to is a series of rules that sort of very blatantly walk around the Civil War amendments without directly violating them. Somebody with like half a brain and mild enthusiasm for racial equality would have shut them down immediately, but after the Hayes deal for the presidency, that enthusiasm is gone. So what you end up with is a post-Civil War era racial setup that is often referred to as the era of Jim Crow. Jim Crow is broken down like this. African Americans are segregated from participating in the same parts of society as whites. You've probably seen bathroom signs or water fountain signs, coloreds only. This kind of stuff was legal. But not only that, but you think about how cyberbullying is such a big deal in the United States today as an issue. You can find pictures of things like gas stations from the South and things that say outside the gas station, things like no niggers or apes on the sign. This kind of just, even you might say, well, just don't use that gas station then if you're black. What's the big deal? But to be constantly bombarded with signs in people's shop windows that you are not welcome, that you are not human in the eyes of the shop owner or the eyes of the gas station owner or the eyes of the restaurant owner. And to have that just not just be politely said, well, whites only, but to be told that you're considered basically the same as an ape constantly in signs everywhere. This sort of aggressively degrading language. This was the everyday existence for African Americans from the 1880s all the way to the 1960s. The other thing that takes place in Jim Crow is that African Americans are denied access to voting through four major means. Poll taxes. Since the Constitution forbids banning people to vote because they're black, they come up with other ways to keep African Americans from voting that don't say it's because you're black, but target African Americans intentionally, right? So one of them is poll taxes. If every African American is a newly freed slave, as you can imagine, most of them don't have a lot of money because they've never been paid for their labor their entire lives. So if you have a tax on voting that is sufficiently steep that all of the newly freed slaves who are poor can't afford to pay it, you can wipe out the entire African American voting population with one swift stroke. It also helps, by the way, that you're not going to allow African Americans to work in jobs alongside of whites, to sell goods to whites. And so you effectively can cut them out of politics by cutting them out of the commercial activity of society on the one hand, and then asking them for money to participate in politics on the other. And if you heard somebody defend these poll taxes back then, they would say, it's not based on race. We just think that people who can't afford to pay the tax, they shouldn't be voting because they don't have enough stake in society, right? And that sounds like a very nice, clean, antiseptic, not racial argument, but it hides the real motive behind it, which is that they wanted to keep African Americans from voting. In today's politics, laws that limit voting based on voter ID or laws that outlaw felons from voting have very similar intention. They are designed to keep minorities from voting. They target minorities disproportionately to white people. And that's why those things are chosen as the standards, right? You could say, oh, well, I just want people, I just want people with IDs to prevent voter fraud, right? But if you look at the statistics, there is very, very little evidence that there is any voter fraud happening at all in American voting. So that can't possibly be the motivation, right? As we'll see in a minute, the amount of African Americans convicted of felonies as a percentage compared to whites is such that, if you outlaw felon voting, you'll take out a bunch of white people too, but you'll take out a lot more of it as a percentage of African Americans from voting. And in doing that, you weaken the power of African Americans to defend themselves from discriminatory laws in the legislature. Another way that African Americans were shut out of voting is through what was called the grandfather clause. Rather than saying you can't vote because you were a slave, the South passed a law saying that you couldn't vote unless your grandfather had also voted. You might say, well, isn't that the same thing as basically saying you can't vote if you were a slave, because if your grandfather was a slave, they couldn't vote? Yes, it is basically the same thing. But again, remember, there was no enthusiasm for standing up to the South on these issues anymore. Third, they have had things called literacy tests, right? Again, on its face, it sounds like it's not very discriminatory, right? Well, if you can't read, you shouldn't be voting, right? Makes sense. Except you have to remember, again, the context in which the argument's being made is one in which African Americans are being segregated from society and they go to different schools. I'll give you an example of why this is such a big problem. In the state of Maryland, when Plessy versus Ferguson is decided in 1896 that says segregation is legal, there is one school for African Americans in the entire state, and that school is in Baltimore, Maryland. So if you live in Western Maryland, out by West Virginia, out by Pittsburgh, Pennsylvania, then the only school you can send your kid to if you're black is in Baltimore, which is 7 hours by car away. And by the way, cars don't exist yet, right? Or if you live out on the eastern shore of Maryland, to get to Baltimore, you would literally have to go up into Delaware, into Pennsylvania, and back down the other side of the coast of Maryland to get to Baltimore. Not exactly an ideal commute just to get to school when you're in second grade, right? So there were very few African Americans who had any access to any education at all, and the few that did have access had access to really substandard education. This meant that that African Americans simply didn't have a lot of access to being able to read. So laws that targeted this were not targeting literate voters versus illiterate voters, they were targeting blacks. Finally, if somehow you were able to become a literate person whose grandfather voted and you had enough money to pay the taxes and you were black, people would put white hoods on their head and beat you to a bloody pulp if you tried to approach the polls. So this was how African Americans ended up shut out almost entirely of Southern politics. And it is a dark and disgusting part of our history, but it is what happened. The beginning of this overturning starts in the mid-1950s and will continue into the 1970s with the modern American civil rights movement. The most important part of this movement, symbolically if nothing else, is the Supreme Court case Brown versus Board of Education in 1955. Brown v. Board of Education overturns Plessy versus Ferguson and argues that separate is inherently unequal. There is no such thing as separate but equal. The court says we have 80 years of evidence now, or 70 years of evidence. No, really, it's more like 60. I can't do basic math because I think it's 1895 to 1955. Well, whatever. Many decades of evidence exist. And it's turned out separate but equal hasn't happened. It's been separate. It's been unequal. It's got to go. One of the interesting things of Brown versus Board of Education is that the attorney who argues for Brown against the Board of Education for getting access to white schools is a young attorney named Thurgood Marshall. Thurgood Marshall would later become America's first black Supreme Court justice. Thurgood Marshall wanted to go to University of Maryland Law School in Baltimore. Maryland did not want to admit him. He had to actually, talk about great training for law school, he had to sue his way into the University of Maryland Law School, where he then graduated with full honors and became a civil rights attorney. Basically, he was motivated to become a civil rights attorney because he had to fight for his own civil rights just to get into law school to be an attorney in the first place. This ended up setting him on a career path in American history where the state of Maryland took him to court to keep him from law school as a young man. But the day that he died, the state assembly at Maryland, the House of Delegates, voted to put a statue out in front of the Maryland General Assembly in honor of Thurgood Marshall and his life the day that he died. And that statue is there and stands to this day. The other interesting story in Brown versus Board of Education is that ultimately desegregation in schools had to be enforced by the President of the United States sending federal troops to enforce the court's decision. Whereas Andrew Jackson once said to the court, they've made their decision, now let them enforce them, and he defied them, President Eisenhower enforced the Supreme Court's decision. And this was an interesting choice that Eisenhower made for this reason. Eisenhower himself was fairly prejudiced when it came to race and racial equality. He did not agree with Brown versus Board of Education. He felt personally responsible in a bad way. We would not think of it in a bad way today, hopefully. But in a bad way, he thought he felt responsible for appointing the justices on the Supreme Court who ended up tipping the balance in Brown versus Board of Education. So Eisenhower didn't agree with the decision. But Eisenhower, and I think this is very much to his credit as a president, Eisenhower enforced the decision anyway because he thought his job as president was to carry out the orders of the Supreme Court, whether or not he agreed with what those orders were. This commitment to the sense of the limits of the presidency, which he didn't have to observe, because had he not observed them, there would have been enough popular opinion behind him to let him get away with doing that if he'd wanted to. But he felt like it was the obligation of the office of the president not to do what you can get away with, but to do what you're supposed to do. And in this case, you're supposed to enforce the decision of the Supreme Court. If you look at the picture on the right, this is a very famous picture of Hazel Bryan walking to school on her very first day to high school at Little Rock Central and being screamed at by Elizabeth Eckford. And this image became very, very famous in the United States, and Elizabeth Eckford became sort of the face of white hate in the American South for many northern readers of magazines and newspapers. One of the interesting stories that has come out of this picture is that several years later, decades later, when both of them were grown women and had children, had families, Elizabeth Eckford tried to find Hazel Bryan to reach out to her and to apologize and to say that she felt awful for her role in this, and she has to live with the fact that she's famous for this for her whole life. And Hazel Bryan not only forgave her, but expressed sympathy that her whole life has been characterized by this one picture. And she said that must be awful, and I can't imagine what that's like. And so one of the interesting things that happened then is every time on the fives that a decade goes by, news media pick up on the anniversary of Little Rock Central, because it's a very historic moment when the school gets integrated. And somewhere in around like the 1980s, I think 1985, media people started asking if they would be willing to sort of appear on radio or television together to talk about that day, to talk about their experience. And so they did. And they started doing lots of these media events together and sort of traveling together and doing radio shows together and TV appearances together. And over the last 20 to 30 years, they've actually become very good friends. And in the way, Elizabeth Eckford and Hazel Bryan become this very nice sort of allegory for the path of civil rights and also the path of healing in American society, that reconciliation between people is possible, that friendship where people were once enemies is possible, forgiveness is possible, acceptance is possible. These two women are, in a way, through their own life's trajectory and the own decisions they made as individuals, sort of characterize, I think, what we like to think of as the best of the United States and its people in general. The civil rights movement itself is composed of many parts. There were legal challenges to discriminatory laws and practices. Groups like the NAACP supplied attorneys, looked for cases, looked for ways to sort of bring down discriminatory laws and get them declared unconstitutional. There were educational challenges, and there still are to this day, right? There are groups like the United Negro College Fund that still try to collect donations and resources to try to help African Americans close the education gap in the United States, which has always been related not just to issues of racial discrimination, but also other deeper and thornier issues like poverty and community development issues, sort of in a more broader sense. And we work at these issues, but with the sort of digital age as it has emerged, these challenges have actually gotten in a way greater rather than lesser, because the economic advantages to being on one side of the digital divide than the other have caused real social and economic problems in the United States. Third component of the civil rights movement is social movements like Martin Luther King's NSLC, National Southern Leadership Council. Social movements did things like picket. They would demonstrate. They would do sit-ins. They tried to call attention to injustice. They are the publicity machine of the civil rights movement. Fourth and final group we want to sort of just mention here are radical revolutionaries, groups like the Black Panthers, the Nation of Islam. These groups were advocates of using violence to assert the power and strength of African Americans and the African American community in the face of domination. They believed that only if whites were sufficiently afraid of African Americans would they ever get what was truly owed to them in terms of their rights as Americans. And these radical groups did terrify a lot of people. And Martin Luther King sort of acknowledged at various points in his life that the fear of more radical groups probably helped in accelerating the acceptance of his nonviolent message, his inclusive message, because the non-inclusive message was terrifying. These radical groups did not end up winning the day, right? The inclusive groups ended up winning the day for the most part. And this is an important thing for a couple of reasons. One, it shows just how important Martin Luther King was, that the moderates won in this case. You know, when you look at conflicts in places like Syria, right, what we wouldn't give for a moderate figure that everyone from all sides could really ultimately get behind and believe in, so that you could get past the violence and get past all of the recriminations of the past and move into something that looks more like a forward-looking sort of destiny, right? We lucked into that in the person of Martin Luther King Jr., and it's fantastic that we did, because imagine if we didn't, imagine how radicalized the African American movement might have become, in a mainstream way otherwise, and what kind of violence and issues that might have created in American society. The other thing that's significant about the radical groups is that, of course, the Black community then has this schism during the civil rights movement between the nonviolent people and the violent people, and the people who advocate violent means they're a real presence in the civil rights era. They don't win. And so the African American community doesn't just have to reconcile with white America, they also have to reconcile within the black community between these schisms that happen in the right approach to civil rights. They all ended up condemning one another as either being too soft if you're in the Nation of Islam and you're looking at Martin Luther King, or too violent and not respectful enough of the rights of white people if you are in the National Southern Leadership Council. So this is a divide in the African American community that has had cultural importance to them that continues to this day as well. Okay. Lastly, I want to leave you with some sobering facts about the status of race in the United States when it comes to black Americans. African Americans are 13.5% of the U.S. population. They are 50% of the United States prison population. They are 8%, if we round up and are generous, of the population of the United States Congress. They are 14% of 14% of African Americans, I should say, are unemployed, as opposed to the national average of 7%. So half of the prison population in the United States is comprised of black Americans, even though black Americans make up 13.5% of the population. 8% of Congress is black, even though they make up 14% of the population. And twice as many black Americans are unemployed as are Americans are generally for the national statistical averages. This combination of unemployment, prison problems, representation problems, economic problems show that African Americans still face a lot of challenges to make up for lost ground that has been inflicted upon them by American history, from working for a living and getting absolutely zero wages for 200 years, from the mid 1600s to the mid 1800s, to being completely shut out of society and the economy from the 1880s to the 1960s. The toll of these actions on African Americans has been devastating, to say nothing of the fact that in order to keep slaves from rebelling, they had been intentionally kept away from education for a couple of hundred years, to keep them from being able to rebel against white plantation owners. Their families were intentionally broken up for generations and generations. So when people look at the African American problems and say, well, here's your problem, you need to care more about education and the family. Right? These things are not just simply values, they're also habits. And these habits have been intentionally disrupted by American society for generations. African Americans have closed an enormous amount of this gap in an incredibly short period of time, aided by sort of more enlightened American policies on these things. But there is a long way to go. And the problem with the civil rights movement going forward is that the sort of low-hanging fruit has been taken care of. The problems, the impact of the history of racial discrimination in the United States, the problems are a lot more complex and a lot stickier today than they were 60 years ago. 60 years ago, if you have laws that say that basically if you're black, you can't vote in the South, you can get rid of those, and that makes an enormous amount of progress with the stroke of a single pen. But if there are problems with access to education, economic problems, community problems, these are problems that are very difficult to solve. They're very difficult to solve while trying to help one racial group and not necessarily giving the same aid to other racial groups. They're hard to solve because the solutions are expensive. They're hard to solve because these are problems for whom the people who are literally culpable for creating them have been dead for a long time. And so you can't necessarily put together a story here about what exactly is the one right way to go forward. We feel our way through this problem as best we can. We keep it on the table as a political issue. But as we'll see with also with women's rights and the rights for other groups, the biggest jumps happen early because the most blatant obstacles get taken away in the beginning. But once you take away the most blatant obstacles, there are a lot of smaller, harder to find obstacles that it gets very difficult to find and to do something about. So that's the slideshow for today. That's your class. I hope that this wasn't too stupid in my doing this. I hope it was good enough to listen to, and I will see everybody on Monday. Thank you very much for taking the time to listen to this.